one of the points I hope to get across today is that checklists do not guarantee compliance when it comes to food. There are numerous principles of law that regulate the composition and marketing of food. The legal principles go beyond the requirements of the food standards in the Food Standards Code. And we've had situations where products that have been quite successful in the market for a number of years, at some later stage, have had their composition challenged by a regulator for an unacceptable ingredient. And take the case of a well-known product that has been imported into Australia for years by the shiploads. Suddenly, after many years in the Australian market, they're blocked from entry into Australia just a few weeks before the Christmas season, supposedly because there's too much caffeine in the particular drink. Now, similar failing food notifications could potentially apply to a wide variety of products. These problems would be prevented if non-compliance risks were addressed at the very earliest stages of product development. One also needs to consider Australia's particular nuances in relation to compliance. I emphasise food composition and labelling compliance goes beyond the Food Standards Code requirements. The Australian consumer law, as interpreted by the courts, requires that such things as the product's name, the product's descriptors, and all the representations and pictorial depictions of the product, and the advertising and the marketing must not be misleading or deceptive. Food Legal has intervened to negotiate and prevent product recalls for foods where a particular ingredient was overemphasised, such as when a berry fruit used for flavouring was pictured on the front of a pack. The ACCC was very unhappy that the front of pack did not mention there was also apple juice at 4 times the amount of the berry juice. And despite the apple having a technological function as the essential carrier for the berry flavour, and also despite the apple being on the back of pack ingredient list in exactly the right quantities, the ACCC is a very aggressive agency, and one needs to be very mindful it acts independently and on its own interpretations of what is considered to be misleading under Australian consumer law. Now, the regulatory requirements for foods are changing, not just because of changes to the Food Standards Code, but mostly because there are always new products or new marketing claims that are the catalyst, and fresh advice and new legal interpretations are required for every new product and every marketing campaign. It is critically important to be focused in the early phase of your product research and development on the actual markets for the end products that will use your company's ingredient. If you want to have your ingredient used in an end product, but it turns out your ingredient is not permitted in that product category, or if the functional claims that your ingredient might offer an end product are not permitted as claims, sometimes because the product is ineligible for that type of claim, then you could be wasting your time on your research and development, and some of your magic ingredients will never reach the target market if the functional claim is not permitted for use in relation to the end product. Just to mention also, the consequences of non-compliance could include a food recall, loss of reputation for the brand, a court order for corrective advertising, criminal prosecutions, a substantiation notice being served, an infringement notice being given, or a big fine imposed, and a range of other court-enforceable obligations, such as having to implement an improved compliance culture in your company, being forced to undergo a round of ongoing audits under the supervision of the ACCC or some other agency. The first thing our role is as food consultants or food compliance lawyers is to assess the extent of the non-compliance risks. One of the first and most important steps is to categorise your product to see where it sits in relation to a particular food standard in the Food Standards Code. Is your product permitted as an ingredient or as a final food? In what form and in what quantity? Is it an additive? Or is it a natural food extract or a food concentrate that happens to have a technological function? Is it a permitted nutritive substance, or is it a novel food that requires a pre-approval? What permissions are necessary? And many more questions. Apart from our role assessing the product or ingredient, also ask the same questions about the end products manufactured by the customers, the categorisation of the end products having regard to the product function claims, and the potential compositional restrictions will also influence the method of compliance with the Food Standards Code. But in some cases, a product might not even be able to comply with the Food Standards Code. It might need to be governed by the Therapeutic Goods Act, which is a very different regime. Which brings me to the next question, which is, what is the interface between a product being either a food or a therapeutic good, such as a complementary medicine? Traditionally, there have been 4 key criteria to distinguish a therapeutic good from a food. First, does the composition of a product have something in it that might disqualify it from being a food? There are different ways to tackle such a problem and not necessarily requiring reformulation. Secondly, the form or the presentation of the product, such as a capsule, might mean a presumption of being a therapeutic good. On the other hand, nowadays we also have functional powders and effervescent pills that can be food in new forms, so they're not necessarily governed by the Therapeutic Goods Act. Thirdly, each functional claim for the product is also an important issue to be considered. But when will a functional, nutritional or health claim covered by the Food Standards Code cross that line and become a therapeutic claim regulated by the Therapeutic Goods Act? An interesting question that Jenny did not elaborate on, so I might just mention. There can be similarities between a food and an oral therapeutic. Each of these can have a functional quality to help the consumer overcome a less than optimum health condition. In our experience, different food agencies in different parts of Australia can have different approaches, and sometimes the distinction between a health claim and a therapeutic claim becomes very artificial. It depends on the product, the claims, and the relevant agency. Fourthly, one of the criteria for defining therapeutic products is that they are consumed in dosages. But nowadays, similarly, it is not out of the ordinary for a food label to specify the recommended serving quantities or the restrictions on daily serves or daily intake. There are in fact numerous food standards also that further prescribe the need for declarations and medical type warnings on particular food categories such as special purpose foods and formulated beverages, apart from the mandatory declarations about allergens. So where is the line? The truth is that for many products, Food Legal has adopted the view that one may find it is open to choose how your product is to be categorised and regulated. As I said, there are many similarities between foods and oral therapeutic goods. Remember, even Coca-Cola began life as a therapeutic product, and so did Pepsi, which was meant to stop dyspepsia. Now, sometimes clever food marketers can convey a health message of a food in a very simple way. A product's placement on the same supermarket shelf as a similar therapeutic product equivalent is just one example of a subtle way to convey a health message for the food. Now look at this list. A performance multivitamin effervescent drink could become an energy drink. A weight loss product could be transformed into a formulated meal replacement. A complementary medicine, such as a herbal remedy or botanical extract, could become a herbal infusion or a herbal tea. A dietary supplement could be transformed into a fortified supplementary food. A probiotic culture could become a yogurt product. They're just some of the examples. But there are always going to be special requirements for every food standard. And bear in mind, Always think about how you're going to get your health message across without breaching the Food Standards Code restriction on health claims. Also bear in mind that under Section 7 of the Therapeutic Goods Act, the TGA has the power to declare that a product is or is not a therapeutic good. A declaration can be made regardless of whether or not a product falls under the definition of food. So as I said, depending on the particular state jurisdiction where you are based, some food regulatory agencies have different interpretations and different enforcement policies. Even if you have a choice to become a food, never be fooled to believe that just because that particular product is governed in a certain way overseas, that same law has any relevance to Australia. In particular, the United States has a completely different regime. And New Zealand also has peculiar laws that can be used either as a help or a hindrance, but that would need a whole other topic, and the advice is also very product specific.